Well, good morning, everyone. Welcome to the March edition of She Infinity and the New Hampshire Tech Alliance's HR Exchange. My name is Jim Reedy, and again, I'm a partner at She Infinity. I'm just thrilled to be here this morning. And as we start, just before we start the program, I'd like to talk to you a little bit about what's coming up later this month and also later this spring. As you can imagine, we've got lots of events coming up. March 23rd, we've got transitioning small and family businesses to the next generation, small and closely held businesses. Where do you start? And two of our corporate partners are going to be talking about that. That's going to be John Purton and Alex Pyle. That's on March 23rd. And go to our website for purposes of registering for that event. That is a free webinar. All of these events are free webinars for purposes of, because we're still in the throes of COVID or the post-COVID era where we're doing webinars and the like. And we'll probably do those, and you will as well, in the months and years to follow. We've one of the benefits of COVID. But next month, April 13th, is another Tech Alliance HR Exchange meeting, and that's Abby Martin. And it's going to be talking about the employer guide to unemployment benefit process, that process, which was, I think, largely misunderstood and taken for granted until COVID hit, and then all things were turned upside down. Abby is an associate with our firm, and she truly specializes and has become an expert in this regard. And now we're seeing the next wave where employers and employees are having to pay back monies that were issued in error during the COVID crisis. And Abby is going to walk through that process along with the normal process of when an employee is separated and the employer has to contribute to the unemployment benefit through one form or another, through pay-as-you-go or the employer tax. May 26th, I'm thrilled to say, is going to be the return to our annual employment law seminar. Now, there'll be more information coming on that, but it is the Thursday before Memorial Day. As usual, it's our annual labor employment law review and update. And as you know, for the last 2 years, we have not been in person because of COVID. And we're going to be talking to you a bit about the time, the place, whether we're in person or virtual, and what the agenda is going to be. So stay tuned for that. And then our June program is a year in review, and that is June 8th. We take the months of July and August off, and then we're back at it in September. So you'll be seeing more information on that through LaborNet. This program is eligible for HR credits. You will see that at the end. There's a slide at the end. In addition, Liz Tezik from our marketing group will be sending out an email with a PDF of this program, with the recorded information, the recorded webinar, and also your HR credits. So stay tuned for that as well. So HR professionals, so we have more than 180 people registered for this session this morning. And that's because HR professionals wear many hats. And one of those is the C-suite turns to the HR professional and says, we've got a problem and we need you to investigate. It could be an issue with a supervisor. It could be a complaint by an employee. It could be issues regarding everything from sex harassment to drugs and alcohol in the workplace, to weapons in the workplace, to theft, data breach, and other forms of misconduct. Just something that needs to be looked into, but especially in the area of discrimination is where we typically see that. And as the standard in the law for purposes of defense is a prompt and appropriate response. And what is a prompt and appropriate response? It depends upon the circumstances, but prompt means prompt. Appropriate means whatever is necessary under the circumstances. And I'm thrilled to say that we're joined this morning with Bree Devonshire, an associate in our firm, a litigation associate, and she has experience in this area. But in addition to her experience as doing internal investigations with partners in this firm, she has what I would say is a razor sharp intellect, step by step through a process. And then in the years that she has been working in the firm, I've been truly impressed with her acumen, her work ethic, and her approach to the law. I think you're really going to enjoy this program and Bree's approach to it. I'm going to stay with you as well because this is what we do. We do internal investigations, and to the extent necessary, I'm going to chime in at the Q&A session at the end. But in the meantime, please join me in welcoming Bree Devonshire. Bree?
Jim, I'm excited to be here with you guys this morning to talk to you about internal investigations. As Jim mentioned, we'll have time at the end of this presentation for some questions. So let's get started. It's Monday morning and you're starting your busy week as a human resources director. An employee comes into your office, closes the door, and tells you she thinks she is being sexually harassed by her supervisor, who is also the head of her department. What do you do next? The answer is an internal investigation. This presentation will cover the basics of conducting an internal investigation. No two investigations are exactly the same, but there are considerations that are common to most investigations. So when should you conduct an investigation? An employer should conduct an investigation upon receipt of a formal or informal report of a violation of company policy, violation of law, a safety incident, a data security breach, an incident that places the company at risk, or an event that might cause the company to initiate or defend litigation. Why are these internal investigations important? Some federal and state statutes require employers to conduct investigations. Examples of such statutes include anti-discrimination, anti-harassment, and whistleblower laws. In other words, employers can be held liable to its employees for failing to conduct an investigation. Similarly, employers create risk of liability for failing to conduct a thorough investigation. Properly conducted investigations also help companies develop defenses to claims and minimize risk of retaliation claims. Because investigations play such important roles, employers must understand the process and product of any investigation may become public, despite any efforts to maintain confidentiality. If litigation ensues, for example, a plaintiff may be entitled to obtain in discovery details regarding the investigation. Companies should anticipate an external examination of the investigative process and result. So how are internal investigations measured? Employers are held to a standard of reasonableness, which is a fact-dependent test. In other words, there is no hard and fast rule that an investigation must be concluded within 3 days of receipt of a complaint. Rather, investigations must be initiated and concluded in a reasonably prompt time under the circumstances. Investigations must be reasonably thorough, and the factual findings must be reasonably accurate. The resources a particular employer has to devote to an investigation, the graveness of the allegations, and other factors impact whether an investigation was conducted in a reasonable manner. Employers cannot compromise on objectivity, however. Companies must understand that a third party, such as a court or jury, operating with the benefit of hindsight, will examine the fairness of the process more closely than the outcome of the investigation itself. If the process is deemed to have been rigged to reach a desired conclusion, it is likely that the employer will be found liable on the basis of the investigation itself. So is there anything you guys can do before a complaint is received to prepare for what a situation that might lead to an internal investigation? Yes, there is. Employers should develop and implement a plan that allows employees to make complaints and outlines the steps the company will take upon receipt of a complaint. These policies should be crafted before a complaint is received, so they are not manufactured under the pressure of the events or on the fly. Effective policies give clear direction about to whom complaints should be made, when they should be made, how they should be made, and how they will be processed through the investigation. Policies should openly encourage employees to make complaints. Other policies dovetail with the investigation process, so efforts should be made to harmonize company policies with the predictive investigative tasks. For example, a computer use policy that makes clear to employees that all emails sent or received on a company computer can be reviewed by the company facilitates the investigative process because it allows the investigators to review emails as part of the investigation. So how do you actually begin an investigation? What are the steps you should take? The following steps are normally part of an internal investigation. They may or may not apply to any particular investigation depending on the circumstances. Employers should consider implementing temporary measures to protect the complainant during the investigation. Employers should be careful, however, that measures taken with the intention of protecting the complainant aren't actually perceived as retaliation for lodging the complaint. Transferring the complainant to another department might be construed after the fact as punishment rather than protection. Employers are obligated to implement measures to preserve information that might be relevant to the investigation or any subsequent litigation. Companies should consider implementing a formal litigation hold pursuant to the company's written record retention plan. Consider obtaining forensic images of important repositories of electronic information and taking steps to preserve important documents. Choosing the right investigator. So even the choice of investigators can be second-guessed. A poor choice of investigator can compromise the objectivity and thoroughness of the investigation and thereby expose a company to liability. Important qualities for an investigator include objectivity, a talent for getting people to talk, the ability to deal with sensitive topics, an understanding of the possible legal claims that could flow from the complaint, and an understanding of the business operations. Do not assign the alleged wrongdoer or someone with a personal stake in the outcome of the investigation as the investigator. Note that it is wise to train investigators in advance. An employer should consider using a third party, such as an outside counsel, to conduct the investigation, particularly if the complaint involves high-level management or employees who have supervisory authority over available investigators. Retaining counsel to conduct the investigation decreases the chance that the objectivity of the investigator will be questioned. The use of legal counsel also allows a company to invoke the attorney-client privilege and work product privilege during the investigation and presentation of a report to the company. Some options for who you might choose as an investigator include human resources, department investigators with special knowledge, in-house counsel, labor and employment counsel, or an outside agency. You're going to want to limit the knowledge of the facts that a complaint was filed, and that an investigation is underway to only those employees who need to know. Doing so decreases the chances of retaliation against the complainant. Confidentiality might help the investigator discover facts without affording witnesses time to formulate their stories or coordinate their stories with others. All those participating in the investigation, including the complainant and any interviewees, should be instructed to keep the matter confidential. The complainant and interviewees should understand, however, that the information they share with the investigator may also be shared with management as the company considers any corrective action resulting from the investigation. Moving on to the interview. So the first question is, who do you start with? It's usually wise for the investigator to start by interviewing the complainant to get as much detail as possible about the allegations. But in some situations, you might not want to start with the complainant. Other people you might want to consider interviewing include other factual witnesses and the alleged harasser. You should be open to adding or subtracting witnesses from the preliminary list as the investigation progresses. Notes taken from the initial interview of the complainant can be used to generate a template for interviews of other employees and witnesses. Creating a template helps to ensure that all topics are covered with all interviewees, even to find out that a particular interviewee does not have any knowledge on a given topic. The interviewer must always ask the complainant and all interviewees, is there anything else I should know? This question could prompt anybody to talk about something the interviewer might not have considered. The interviewer must account for witnesses' motivations and biases because all interviewees bring their own experience to bear, even if they profess objectivity. Understand that eyewitness accounts are often unreliable. Interviewers will find that several employees who each witnessed the same event will describe the events differently. This phenomenon is exacerbated by the passage of time and fading of memories. Investigators will be called upon to resolve factual differences between witness accounts, and there is often a qualitative difference between firsthand observations and hearsay accounts. It is often wise for the investigator to return to the complainant after interviewing other witnesses to follow up on accounts that differ with the allegations of the complaint. Keep in mind that the number of interviews, the scope of the investigation, those may both be questioned. A usual attack is to suggest that an important person was not interviewed. Companies are not required to scorch the earth and interview every person who possibly has information. Again, the applicable standard is reasonableness. However, thought should be given to the number of interviews conducted, and as a general rule, the investigators should be given latitude to decide how many interviews are necessary under the circumstances. In other words, it may look bad if the company places a limit on the extent to which an investigator may investigate the case. This review also ensures that any discipline given out is appropriate. Some thought should also be given to the location of where to conduct the interviews. You want to choose an appropriate location to conduct the interviews, one that takes into account the desire to maintain confidentiality. When reviewing the documents, the investigator should look for and examine documents and other evidence that relate to the complaint. The interview should be aimed in part at identifying locations of evidence that might support or refute the claims. Those looking to challenge the quality of the investigation will often criticize the investigator for failing to look at repositories of potentially relevant information. Documents and other tangible evidence often prove to be more reliable than interviews because documents created contemporaneously with the events crucial to the complaint are not plagued by fading memories or motivations brought on by the fact that an investigation is underway. It is also important for an investigator to learn how the company responded to similar complaints brought by other employees. As another common criticism is that this complaint or alleged wrongdoer was treated differently than other employees. Consider whether IT will have a role in an internal investigation. In some investigations, IT should be immediately involved to retrieve evidence prior to conducting any interviews. You'll want to evaluate whether an employee's computer should be disabled. And don't forget to continuously reevaluate IT's role in the investigation as the investigation progresses. The investigation ultimately culminates in a written product documenting all the steps taken, when the steps were taken, the documents and information considered, and any information that was not considered, and why it was not considered. The report should emphasize the factual findings and minimize legal conclusions. The report should highlight consistencies in the evidence, identify inconsistencies in the evidence, and resolve inconsistencies when possible. If judgments are made regarding credibility of particular interviewees, those should also be identified. If any assumptions are made, those should be explained. The investigator will likely develop recommendations for corrective actions and possibly discipline to impose. And those recommendations should be included in the investigative report. The investigation notes and report should be kept in a file marked confidential that is separate from the personnel file for the impacted employees under similar circumstances. Any considerations influencing the decision to discipline or not discipline employees should be documented carefully, particularly where company management does not impose the discipline recommended by the investigator. Careful consideration must be given to any future discipline imposed on the complainant or any participants in the investigation, even if it is imposed well after the initial investigation is concluded. It is unlawful to retaliate against a complainant for making a complaint or against a witness for participating in an investigation. Even if several years pass between the participation in an investigation and a subsequent event warranting discipline, an employee may draw a connection between the two events and assert that the subsequent discipline is really unlawful retaliation. The investigator and perhaps management should meet with the complainant at the conclusion of the investigation. It is important to thank the complainant for bringing the matter to the company's attention. The investigator should summarize the steps taken, the findings made, and any corrective measures implemented. The complainant should be given instructions to come forward with any future complaints, particularly if this investigation did not find support for the allegations. Supervisors of the complainant should be instructed regarding the risk of retaliation claims. So after you've completed the internal investigation, or after an investigator you've hired has completed the internal investigation, there's likely going to be some aftermath that you're left to deal with as a human resources officer. And this is a list of actions you'll want to consider taking or choices you will need to make once the investigation is wrapped up. So you'll want to determine what to do with the investigation materials. As I mentioned previously, you're going to want to keep the materials separate from the personnel file and keep them marked as confidential. This makes these materials a little harder for anybody to have access to. But as I also mentioned, they can always become public. For example, if litigation ensues and the complainant seeks the investigation materials in discovery. You'll want to determine who should receive the investigation summary. Is it just going to stay with management? Is it going to go to the complainant and the alleged wrongdoer? So that's something you'll have to decide with what to do with the summary. You'll have to determine who acts upon the investigation results and what information is shared or not shared with the decision maker. You'll have to determine what is communicated and what is not communicated to the participants in the investigation. And you'll have to be prepared to address the complainant's insistence about knowing the outcome of the investigation in terms of the employer's action against the alleged wrongdoer. Additionally, you'll want to warn mostly everybody that participates in the investigation that retaliation is strictly prohibited. You want to coordinate as appropriate with supervisors to guard against retaliation claims. You'll want to follow up periodically as appropriate with the complainant and the supervisors. And bear in mind that any participants may claim a protected status due to participation. So that is the end of my presentation. We now have time for questions. I believe you can submit the questions, and Jim and I will do the best we can at answering them.
Bree, to kick things off this morning, first of all, thank you for doing this. And, I think the recipe for doing an internal investigation varies, of course, as you said, from case to case. But when you talked about preservation of electronic documents and otherwise and company policies, what happens if a company does not have a policy? Should the investigator be prepared to address that with the employer and provide them with guidance as to preservation of electronic documents?
Yes, and they definitely should. Often what an investigator will do is implement a litigation hold, and a company will, anybody that's involved in the events that are the topic of the investigation, or depending on the size of the company, the circumstances, it could be a litigation hold for the whole company, which would involve the company sending out a letter to all employees saying they need to retain all documents that might relate to, and then probably some vague synopsis of of the situation or the documents that could potentially relate to the event. So the investigator will help guide the company, but it's a important decision for a company to make, and which is why this is one of the steps you can take before an investigation even begins, is to have a company policy about this. Obviously, with a lot of things being online these days, especially due to COVID, IT's role in internal investigations is becoming more and more important, as a lot of the stuff we have is online or in files on the computer, and it's not a lot of hard copy documents we have anymore. So it becomes somewhat a little bit easier for documents to be retained, but it also means that there's a lot of places documents could be, and we have to, go down all these different repositories on people's computers to figure out where these documents might be. And if people try to hide documents, those are also discoverable, and usually IT can find access to them because employees don't usually bury all the documents enough for IT to not be able to find them.
Well, two quick things in that regard. What happens if, because IT does get involved, as we know, we have limited bandwidth with regard to our storage capabilities. And from time to time, IT will, of course, in the normal course, they will go through when there's data destruction or storage. What happens if something is the employer or investigator is not directing the employer to preserve electronic documents, or in the ordinary course, those documents are destroyed? Is there a presumption that happens in that case if later down the road the complainant, let's by way of example, says, well, I know on this date that there was an email, and then the investigation says there is no such email? What's the adverse implication, if any, for the employer?
So if documents are destroyed in the ordinary course and it has nothing to do with any sort of funny business going on with these documents being destroyed because of the investigation, then there's going to be a little more leeway. But if there's no litigation hold, if there should be a litigation hold, and there probably should be a litigation hold if the investigation is underway, but that would result in some sort of spoliation finding, probably by the court, that documents were destroyed. And there could be an adverse, the court could rule that the jury or the bench itself will take an adverse assumption that the document was destroyed to hide it, and that the document did exist. So you'll want to avoid that situation, because the court, if the document was destroyed and it looks like there was some, funny business going on, and it relating to the circumstances under which the document was destroyed, then the court is going to assume that the document existed and that it said the thing that the other side is saying said the document.
So, and then when you have cases when we're going to go old school here, in the event of paper and a supervisor's notes are important to that investigation. As you know, and we've talked about before, RSA 275-56 and LAB 80209 talk about what is in a personnel file. And it says, as you said earlier, all documents pertaining to the employee, no matter where kept, including but not limited to, and it talks about all the things that are in the statute. So the important thing, I think you mentioned earlier, of gathering together all those documents, no matter where kept, whether it's electronic or paper file, or, because of the problem with, later during the case, after, some level of discovery, suddenly this helpful document surfaces, and it may look suspicious at that point. But in that regard, with regard to personnel files and the like, there is one, as you know, there's one provision that says, and sometimes employers get caught up on this, it says, if at the time of the request to look at the personnel file, the employee is the subject of an internal investigation. And sometimes HR professionals and others will stop there, say, well, I don't have to provide that document because it's the person is the subject of an internal investigation. But if you read on, it says where law enforcement is involved. So it's a very narrow exception. So I think the importance of of making certain that you get the investigator gathers all of that information, I think is critical. Let's go to some of the questions though. First of all, something that we've all heard many times before in the case of an investigation, and it's gender specific, but it doesn't need to be, where there's a differences in the old, the tired old expression is he said, she said, and there are no witnesses, and no physical or forensic evidence. How would you sort this out? So for purposes of, there's a difference between two individuals in a case, someone complaining, someone, I think you mentioned earlier, someone with a very different version of events. How would an investigator sort that out?
It's a hard question. Investigators struggle with that. If you're in that situation, you're likely going to be limited to the people who you can interview. But even if there are no witnesses to that event, there might be similar circumstances or events that have happened that will be helpful for the investigator to know about and to investigate, because they might shed light on this particular he said, she said situation. So even though there are no witnesses to the particular one, other events that have happened could shed light onto the event that has been complained of. So often that is one of the biggest factors that can help investigators and help them, if they're leaning between well, I could see it has happened this way, or I could see it has happened that way. If they see that that one of if the he in the situation has done this 3 other times, then you're going to, looking at the standard of reasonableness, you're going to likely weigh that it's more than likely that it's happened here. But it is hard, because you're limited in the documents, you are limited in the witnesses in that exact situation. And an investigator will need to make a call on which witness is more credible, which witness has motivation to say something against the other, and what biases might be there. But I agree, that's a really hard one. Investigators struggle with that, but the investigator is trained in this aspect, and they're a professional, and they kind of know how to navigate these situations, and they'll need to be making judgment calls along the way.
But therefore, and sometimes supervisors will say this, they'll say, well, I can't decide because he said, she said, or she said, he said, or whatever. But I think your advice earlier was you don't just stop there, you have to make a decision.
Correct. And I think, this is why it's also really important to sometimes have the outside investigator as opposed to an in-house, investigator, because everybody in-house is going to be going in with preconceived notions, with biases on each particular party here, the he and the she. And those are going to influence you, despite how much you try for them not to influence you, they are going to influence you, which is why the third party going in without any biases is really important in these he said, she said situations.
It's happened over the years, and thankfully it hasn't happened very often. But what are your thoughts with regard to polygraph examination of any sort, with regard to, because you question the truthfulness or veracity of someone, so you subject them to a polygraph. What are your thoughts in that regard?
I've never used one, and I've never seen one used. I mean, I think it's not very credible source in court these days, so we don't often see them used. So I honestly have no experience with them. I know that they were used a lot back in the day, but it's not a method that people really rely on these days.
Right, and I think that because it's limited utility in court is for purposes of proving the matter. In fact, it's very, very limited as to when you can use it. It's really in a government security investigation or a police investigation, and even then, it's limited. Let's talk about the investigation report. One of the questions relates to it being kept separate from the employee's personnel file, but do you recommend putting some type of reference in the personnel file to make a connection to, if necessary, an investigative file?
I think that's a judgment call. I think that you can, but you don't need to. These documents can be discovered. So if they are discovered and the employee who made the complaint has access to everything, they're going to get everything and they're going to be reviewing everything. A little note in the personnel file to refer to the investigation report isn't gonna really do anything. So it doesn't really matter if you do or do not include a note. It's not going to harm you. It will do no harm, and it'll provide no benefit either, really.
Yeah, and I think that oftentimes people are reluctant to come forward because it's an investigation, but they don't want to be exposed necessarily one way or another, talking about a coworker. And I think one of the things we've said in the past is that under the statute, a peer review is something that is not a part of the personnel file. So if in an investigation, a peer is making a comment that could be shielded from disclosure, on the one hand, you want candor, but you also have to give some degree of confidentiality in the process. But as you said, Bree, in the end, these things are largely discoverable. You can't hide the ball. Another question, any tip on how to get to the witness to feel comfortable during the interview and feel like they're not being interrogated? No thumb screws, no bright lights shining down on them, no turning up the heat or turning up the air conditioning to make them uncomfortable. How do you, and I've actually seen Bree do this and make someone feel very comfortable and actually disarmed effectively during an interview. So what are your tips on making someone feel comfortable in that process so you can get as much information as you can?
I think the two main things for that are location and the interviewer. You need to have a location where the person is comfortable. Calling into the HR office or the president's office, it's like getting called to the principal's office. Nobody's going to talk then. They're going to be squirming, they're going to be turning red, and they're going to be fumbling over what they're saying. They're not going to be comfortable there. So you're going to want to do a comfortable location where the person has a relaxed feeling. I mean, you got to be thinking about the temperature of the room even, so that they're not, cold, too hot. The chair, making sure they're comfortable so they're not sitting on a stiff wooden chair. I mean, everything about the location of the interview is going to impact a person's demeanor. And then the biggest thing is the interviewer. I mean, being able to conduct an interview and not make the interviewee feel intimidated, embarrassed, under pressure, it's an art. So choosing the right person is really important. And it is, as Jim said, we've all seen people who can conduct interviews and get information out that you would never think could come out from that person. But the way the interviewer goes about it, and they will just pull information because the interviewee sees that interviewer as a friend, somebody who's on their side. I mean, it really is an art, and that's why choosing the right investigator is a crucial thing. And often that's why it's not the best decision to have the human resources person or somebody in management conduct the interviewer, because the interviewee is just going to be looking at that person like, you're my boss, and is going to be very limited in what information they disclose.
Yeah, I mean, my personal preference is to use a litigator, someone who's a trial attorney who understands the discovery process, but also understands how that information can be used later. And they're also, like Bree, trained in these areas of asking questions, making someone feel at ease, and so on. I think, what about when the actual approach to someone? In our termination checklist that we provide to clients, one of them is, how do you notify someone that you're going to be meeting with someone about their discipline or termination? And we just simply say, keep it simple. Just say, I'd like to meet with you for a few minutes, and so on. What do you think about that? Because after you meet with the first witness or two, the word's going to spread pretty quickly that there's a suit down the hall that's talking to people about so and so. So the more people you interview, the greater likelihood people are going to be tense or on edge. How do you diffuse that?
Well, I don't we've had many investigations where word doesn't get out. A lot of employees take to heart the keep it confidential thing, especially if it's, if they're just a witness and it doesn't relate to them. They feel like it's not their business to be spreading this. So many employees do take that to heart. So it doesn't necessarily, somebody might not be tipped off about what's coming when they go into the interview. Often that's, why sometimes location for the interviews is not right on the premises. It's so that, people don't see what's going on. But I think that ultimately, if they're not giving word about what the person is going into a meeting for is really important, as you mentioned. You don't want to tip them off to anything because they're going to have time to formulate some thoughts. They're going to probably have pre-planned answers to some questions they think that might be coming. And we don't want that. We want them to be answering on the fly and sort of talking out loud about what's going on in their head as they think about the questions you're asking. And so, not mentioning what you want to talk to them about is an important part of it. And you don't want them to be nervous about what's happening and then go talk to other people and then be influenced in their narrative by other people.
So interviewing a witness, interviewing the complainant, in many ways is different from interviewing the person who is perhaps responsible for the harassment, the discrimination, the misconduct. What's a different approach with regard to the person who could ultimately be responsible for the bad conduct?
I think the location and the tone of the interview probably does change a little bit. The alleged wrongdoer is that interview is normally towards the end of the investigation. And at that point, the investigator might have a good sense of what's going on and what they think actually happened. And that will probably depend the tone that the investigator takes with the alleged wrongdoer. And in this, every situation is different, depending on what the alleged wrongdoer did. You're going to have to determine how demanding you're going to be in the interview, how intense you're going to be. If you're going to, if the tactic is going to be to try and make them uncomfortable enough that they give more information, or if you're going to, realize that you get, telling them with kindness is the better way. It's all a determination call, depending on the situation, dependent on the players at hand. But, I think the tone and the location are the two things that might change depending on if it's the complainant versus the alleged wrongdoer.
So both the alleged wrongdoer and other witnesses, you're going to talk to them about confidentiality. But with the alleged wrongdoer, you're going to add another element. You mentioned this earlier, and that is you and perhaps the HR person effectively telling the person that they are not to retaliate against and contact others. Why don't you speak a little bit about that?
So one of the biggest issues that happens after an investigation is claim of retaliation. And it's so hard to think of what an employee might conceive as retaliation. You might think you're protecting them by transferring them to a different department, but months down the road, you get a complaint and you're sued for retaliation because you moved them to a different department. So it's really hard to think of, what the employee is how they're going to conceive any actions you're taking. So that's why it's incredibly important to talk to the alleged wrongdoer and some of the witnesses, depending on the situation, and basically tell them, you're not supposed to do anything now. You're supposed to pretend as if this is not happening. You're not supposed to change your behavior. You're not supposed to change the way that you're doing things. And you need to continue on as if nothing's happened, because of the situation we're in right now. We're at risk of there being retaliation claims, and you need to be very, cautious and cognizant of that. So it's, it's important to make sure that everybody is aware that anything they could do could be, perceived as retaliation down the road.
So in that regard, let's talk about specific instances when you would recommend that in addition to the investigator being in the room, perhaps an HR representative is also in the room to give some direction and either guidance or admonishment.
So an HR officer might know the ins and outs of what an employee does on a daily basis. If they have a meeting with all of the people in the department every morning for 10 minutes, or if they send out certain emails. So the HR officer might have really concrete and minute details that the investigator might not have. So the HR officer is a good person to be able to think, okay, well, you do this every day, so make sure you don't change the tone of your email, or make sure that when you meet with these people, as you do every Tuesday, it's the same people that are coming to the meeting and you don't exclude anybody from that meeting. So the HR officer has some hands-on knowledge that will be really helpful in that situation.
Yeah, great. So you talked about creating the investigator creating a report, and we talked about how that is kept separate from other prying eyes that might get to access to a personnel file, because it would be, the contents of the investigation are on a need to know basis, at least initially. How long should an employer retain the investigation report or documentation?
So often company policies will have that information in there. And I think the average is probably 3 to 5 years. It could be a little longer depending on what the company, but I think it depends on how long you keep other documents. If it's common for you to get rid of documents in a personnel file after 10 years, then you don't have a company policy saying how long you'll be retaining a report or an investigation for, then following the rule that you have for other documents in the personnel file is usually a good way to go. But if you don't have a policy, then I would say, I think at least 5 years is a minimum for keeping the investigation. If you don't have a policy, but you can just outline it in the policy, and that'll direct it.
It would be basically the nature of, if it was a whistleblower claim, you look at that statute of limitations. If it's a discrimination claim, you look at that one. But then even with that, if a claim is filed, for the duration of the claim, right? Yeah. So let's talk about, you talked about the many different types of investigations, and they can vary significantly. What guidance would you provide on what types of, meaning the level or nature of complaint, that warrant a formal investigation versus handling it in the ordinary course of like an employee relations issue, like a supervisor or an HR professional just walking up to someone and hey, just be more aware of this or that, and that's the end of it, versus bringing the investigator in, talking to witnesses, looking at documents, and so on?
I think one way to really guide the answer to that is how the complaint is presented or given to HR. If the complainant, sort of casually says to somebody in HR in the hallway, this really bothered me, or if it's a very informal way of reporting it to HR, then I think that's, you're safe sort of using that as guidance for the way you go about deciding if it's going to be a formal or informal complaint. If the HR officer receives a very long email with bullet points and a lot of detail, that's going to probably trigger a formal investigation. If it's a typed up letter and that letter is dropped off with an HR officer, then that's probably going to be a formal investigation. I think guiding it by the way that the complaint is received is one of the, a good way to guide that. But that's not just, somebody could be really uncomfortable with the situation and be really nervous about bringing forward any sort of complaint, and be casually tell the HR officer of something very serious that happened. And, if it's a serious allegation, but even if it was presented to the HR officer casually, that, it's going to be a formal investigation. So depending on the severity of the alleged event or action, you can determine whether it's going to be a formal or informal investigation based on that as well.
And that would also be perhaps even if the initial issue was not as serious, if it's cumulative, if it's a repeat offender, you might have a situation where now you have to get more involved because you could have the severe or pervasive type of argument. My employer didn't pay attention and I told them, or somebody else told them on a number of occasions, right?
Yeah, that's correct, Jim.
So during the interview process, what would you suggest be done if the manager who needs to be a part of the interview process declines because they hang out with this person in their personal life? So, that's not uncommon, whether it's actually spending time with that person as friends and not being able to separate work life from personal life, and one that I can't stand, but it's where the supervisor is a social media friend, Facebook friend, other contact with a person, and they just don't feel comfortable being a part of that process. So what if the manager who needs to be a part of the process declines? What do you do in that case?
And I'm assuming here that if the manager is friendly with this person being the alleged wrongdoer, the manager has a duty as an employee to be participating in the investigation. They can't opt not to just because, they hang out with the person or are friendly with them. That being said, the trained investigator knows that this person is coming in with a bias, with different motivations, probably to protect their friend, and they'll know how to handle and how to perceive a lot of the answers that person gives. So, maybe a lot of the answers that person gives will be taken as less credible than they might have been otherwise if that person was not friendly with the alleged wrongdoer. And it's important to know that the alleged wrongdoer is going to know that this person had to participate in the investigation. They might be upset with their friend for having participated, but it's an employee's duty to be participating in the investigation. And they can't just decline to because they hang out with this person. If they have information, they have to be participating in it if they've been asked to by their employer. And the investigator will know how to deal with this information and how to perceive the answers they get based on the fact that this person is friendly with the alleged wrongdoer. And, that's why it's an important question that an investigator often asks is, what is your relationship with, first of all, the complainant, and then what is your relationship with the alleged wrongdoer? That's information that the investigator will get probably from every person in the interview, so that they can figure out what motivations and biases each interviewee is going in with.
Yeah, excellent. So let's switch gears here a little bit and talk about a union environment. Union environment, of course, being a little bit in New Hampshire, like a lot of other places, you don't have a lot of private sector unions. You have some, but more and more public sector unions. But still, a union environment is where you cannot, you may not be able to interview someone without a union representative present, and there are certain due process rights that attach. In that union environment, where the investigator could potentially, or the investigation could potentially lead to discipline, would the employee be allowed to request union representation during the interview process?
So you might be able to answer this one better, Jim, but my understanding is that, a lot of that will be depending on what the CBA says, and when union representation is allowed or must be permitted, but a lot of it's going to be guided by the CBA and what the actual language in the CBA says regarding that. Yeah,
you're right. I mean, typically it's if discipline could result, then a union representative can and should be present, and that process is usually covered in the collective bargaining agreement. That's right. But because again, it's a bit more of a due process right. But now let's flip back to a non-union environment. The person says, "I don't feel comfortable. I would like to have my coworker sit in with me." And I'm going to give you another one. "I don't feel comfortable in this process. I would like my cousin Vinny, the lawyer, to sit in with me." What do you think about either of those examples? If a person wants to have their lawyer sit in with them, then you're probably going to need to allow it. You can't really tell them that, well, you don't really need that, because you never know what you might find from the investigation, and a person you might not think is
involved or might not have done any wrong in the, in the event at hand, you might find out information later on that they actually did do something, and you'll be in trouble if you denied allowing them, their attorney, into the process or in the investigation. As far as bringing in a coworker or somebody else, it's a confidential investigation, and I think you really need to enforce that. If this person doesn't have any sort of privilege with the interviewee, then that's going to be a problem as it is a confidential investigation.
Yeah, I think I've had those cases where the person wanted to bring their spouse in, but their spouse didn't work there. A person wanted to bring in their parent, but they were over age 18. And I think with the lawyer one, I think the answer is you can be present, but you can't interview and you can't interfere with the investigation. This is not a deposition. You can sit in, but you have to be quiet. So I think that's a touchier one. It doesn't happen very often, but it's a good question just the same. Is there a time that you should give people being interviewed questions beforehand, or is it effectively, I think you mentioned this earlier, how it should be, you don't want them to sort of take time to practice or prepare answers. Is that right?
Yeah, I would say there's never a time I would give somebody questions beforehand.
Yeah.
I can't think of a time I would.
Yeah, I agree. When interviewing the accused, do you share with them what what they're accused of at the beginning of the interview, or do you ask questions in such a way that on the one hand are disarming, that give you context, and that lead up to the ultimate questions?
I think that's a fact, that's a situation specific question. I think it depends what's being alleged. It depends who is being accused. It depends what the character of the person accused is. If disarming them is going to be the better strategy with them, and then you do it that way. If you think going in a little harder is a better way, depending on the person's personality, you do it that way. I think that's a very situation specific question. But I think even if you decide to give a little more information at the beginning, being as vague as possible is important, and not going to details, because you want to try and use the details you've collected from the complainant to guide your questions and not tip off the alleged wrongdoer of where you're going or what little information you might have. So, being very vague, as we've had reports that there's been an uncomfortable, interaction or an interaction that, made somebody hesitant to work with you. Being very vague at the beginning is important if you're going to be giving any detail at all, so that you don't tip them off to what questions you might be asking down the road or what information you might have or might not have.
The notion of constructive knowledge, I think, is important for HR professionals. And there was a case involving Plymouth State University years ago where a faculty advisor received information from a student with regard to another faculty member, and the president of the college, now university, said, "I can't take this seriously unless the person comes forward themselves and the complaint is in writing." I think you said earlier, the complaint does not have to be in writing. Once the employer is on notice, they need to respond in one form or another, right? So in that regard, what about rumors? Someone in HR or a supervisor hears a rumor. When does that become something that should be investigated?
Like I'm giving the quintessential lawyer answer for a lot of these, but it does depend. It depends on what the rumor is, what the event or the action is that the rumor is about. It depends the severity of it. It depends on who you're hearing this rumor from. Is it somebody that often causes trouble and just tries to stir up a lot of stuff? Or is it from somebody that, you don't often hear something from? So depending on the severity of the events regarding, the rumor is about, that's something that the HR officer should be considering. But it's also why it's somewhat important to have, if it's a severe allegation that the HR officer gets through, through the grapevine, then that's why it's important to have an outside investigator who is not privy to all these rumors that might be circulating around the office. It's, once they're sitting down with people and it becomes a more serious investigation, people are going to be less likely to be spreading rumors, and they're going to know that it's something serious and they should stop just opening their mouth willy-nilly about something that's going on. But I think you can look at the severity of the rumor and who it's coming from and the manner it's being tossed around the office, and the person who's saying it, if they have any biases or motivations. So there are a lot of different factors you can look into for figuring out what to do with the rumors.
Yeah, but we don't put our head in the sand. If it's something that needs attention, of course, HR does have to respond. So what if it comes up during the exit interview, the employee is leaving and now feels like the tether of the employment relationship is severed and says, hey, now that I'm leaving, I'm going to want to let you know about, so-and-so's been stealing from the company, or, so-and-so's having an inappropriate extramarital relationship, or so-and-so has used the N-word on a regular basis, or I didn't feel comfortable being here because I thought, so-and-so had violent tendencies and that's why I'm leaving, but I'm leaving. So still investigate?
Yeah, you definitely still have to investigate it, because that might be a constructive wrongful termination suit down the road that they mentioned it in their exit interview, and they could be saying all along this was going on and the HR person should have known, and that I was wrongly terminated because even though I quit, it was, they made the situation uncomfortable enough because they didn't do anything to remedy the situation. So you definitely need to look into it even if it's said in an exit interview.
But what if it doesn't even involve them? I mean, it's like, look, I'm leaving because I've got another job, but I want to let you know that so-and-so is going on and so on. But obviously the person is giving you information that you need to follow up on potentially.
As a litigator, I'm always clued into thinking it could be a lawsuit down the road. A few months from now, you could be getting a lawsuit. This person their new job could end up not working out, and they could be trying to get money, and easiest way could be a wrongful termination suit from their former employee.
What happens, and this comes up all the time, someone comes to HR and says they want to tell you something that happened about an event, a coworker interaction, but they don't want it investigated or brought forward to the person they're complaining about. They just want you to take care of it. What do you do?
That's a tricky one. That often happens, and you're just wanting the HR officer to be aware of it. But the HR officer, like you said, can't bury their head in the sand, and they do have an obligation to look into it when it's being reported to them.
Yeah, I think you offer some degree of confidentiality, but ultimately, like any investigation, I'm still going to need to talk to other people. I still need to address this. But to the extent the person needs to be protected in the process, you offer some degree of protection against retaliation. What happens, and we've got now 3 questions about this. One, the person wants the complaint to be anonymous. I think we just addressed that. It's to the extent possible, but we still need to address the matter and protecting the individual as much as possible. I have a question for you. So one of the last questions I ask, and I think many of us ask in connection with a witness interview or an employee interview is there anything else I need to know? Why is that an important question?
That's the open-ended question that could, if the investigator is trained to ask most of the questions that they're supposed to ask and to get most of the information they're supposed to get. And, a lot of that is based on the initial interview with the complainant. But there's going to be stuff that the complainant either misses, doesn't fully explain, or explains it a little differently that might not trigger a question for the investigator that maybe should have been triggered. And that open-ended question gives the opportunity for an interviewee to mention something that the investigator might not have considered. If the interviewee is just answering the questions that the interviewer asks and, giving the direct answer and not explaining, giving details or giving examples, and they're just doing their job and answering the questions that are asked of them, then you need to provide the opportunity for them to provide information of events or details that you might not have thought of. Often those open-ended questions give you the best and most information, because you're basically giving the interviewee the opportunity to totally talk about whatever they want. And sometimes when somebody's talking for 5 minutes, you'll get a nugget of 10 seconds that is this key information that you would have never thought to ask. And it's important for them to have the opportunity to sort of provide information that's not being directly asked of them.
Yeah, and if the person's being a bit cagey, they can't say, well, you never asked me that question because you left it open-ended. It's like, well, these are the questions I asked you, but now I'm going to leave it open. And the person can say, well, you never asked me, because is there anything else I need to know?
Right. And then going back to the reasonableness standard, the list of questions is discoverable, and the court's going to look and, determine whether or not that information should have been found out by the investigator. And if you see that the investigator didn't ask any open-ended questions for that information to come out, the court's going to be looking about that and thinking it's probably not reasonable that they did not ask any they should have found out that information.
We've had lots of great questions this morning. One is a little bit off the beam, and the question was, does She and Finney do sex harassment training? We absolutely do for employers, and now we're doing them more and more in person because of the COVID restrictions being lifted. And do you do a separate session for managers and supervisors? I'm doing one next week, and the answer is yes. You typically have a plenary session for everyone, and then you have a separate session because of the standards for supervisors and managers. Here's an interesting question. And this is one that perhaps will not come up very often. How do you handle interviewing someone who requires some sort of a reasonable accommodation based upon disability, like using an interpreter for someone with a hearing impairment or a sight impairment? As a litigator doing depositions, this is something that I'm sure you've had to deal with before. So in an investigation, what do you recommend?
You have to, especially depending on who the person is and their importance in the investigation, but you have to provide the accommodation. Again, the reasonableness standard, the court's going to be looking on whether or not you interviewing or not interviewing this person who required an interpreter or is deaf and needed somebody to sign for them. If you didn't interview this person, the court's going to be looking at whether that was reasonable or not. So if it was an important factual witness, obviously, if it's the complainant or alleged wrongdoer, you have to provide the accommodation. But if it's an important factual witness, and it's not, somebody who might have heard something, somebody who might be like a hearsay witness and one of 30 that you're going to be interviewing, that's a different situation. But if it's somebody you should be getting information from, you're going to have to provide the accommodation.
Right. And I'm going to wrap this up with one last question here, and then I'm going to turn it back to you for conclusion, Bree. Do you recommend recording interviews? Now, whether it's an outside investigator or someone in the organization for reference later? And if you do you have to inform the person that they're being recorded? And then finally, what do you do if the party does not want to be recorded?
I would not recommend recording the interview. I would, it's just always copious notes. Take a lot of notes. Recording the interview goes back to that question of how do you make somebody feel comfortable and give a lot of information. If they're being recorded, they're going to be more reserved. So that's one of the reasons you don't want to record, but it's also the recording could come back to bite you down the road. So you're not going to want that recording. You're going to want your copious notes. And yes, of course, you would have to, if you decide to record, you would have to inform all parties. And if one of the parties doesn't want it recorded, you can't record it. New Hampshire is a 2-party consent state for recording. And if they don't consent to it, you cannot record. And that's a federal offense if you record without their consent.
Yeah, great. Bree, I want to thank you for a terrific presentation on how to conduct an internal investigation and the great insights you provided, especially during this Q&A session. So I'm going to turn it back to you for some closing remarks, and then remind folks that Liz Tezik will be sending out an email with we've got a slide with regard to your HR credits, but she'll also be sending out an email with a PDF of this program, a recording of this program, and related information. And again, we've got upcoming events on the 23rd with regard to selling small business. We've got the April event with regard to unemployment. We've got our May annual employment law seminar. Of course, June is our year in review. So thanks again to Bree. Bree, I'm going to have you take it home with closing remarks.
Thank you all for participating today. I got some great questions, and I think it's really helpful for everybody. Nobody likes internal investigations. They're not fun. They put a damper on the work environment, but there are steps you can take to prepare in advance of ever even getting a complaint that are, would be prudent for HR officers to be taking right now. If you guys don't already have company policies in place, it'll help you down the road. And the considerations you'll want to make on, who does the investigation is also important. It could be really hard for the HR officer to be conducting an investigation, which is why, looking to the outside might be an important consideration for you to make as it lessens the liability on you, and you can hire somebody who's trained to do these investigations. But you're never going to want to go into an internal investigation not really knowing what you're doing, because it really could hurt the company down the road. But I hope I've provided some helpful insight. And again, great questions, and thank you all for attending.